Coming to you live from the Now Media Newsroom.
I'm Jim Csek. You're watching Now Media with me, Geoffrey Moyse. Lawyer. He's a retired senior lawyer who served as legal counsel for Aboriginal and treaty law for the province of BC, advising 6 successive provincial governments on Aboriginal law for over 30 years, and currently in private practice. And the second time on this show, and again, the first one I advise people to go watch was a really good one to kind of like really get an understanding of what's going on in like, you know, that Richmond decision, to kind of give people a really good sense of that. And then today we're going to talk about making sense of the BC NDP's Indigenous reconciliation agenda. Welcome.
Thank you.
So we're going to try and make some sense out of this, because a lot of people, you know, it's tough to understand, especially when the NDP is not very transparent in what's going on.
Yeah, what I want to do is help people to understand, hopefully, Canadian law, Canadian constitutional law, and the UNDRIP agenda that's been adopted in BC. So probably a lot of confusion about that. So maybe we can clarify some of that.
Yeah, maybe make sense of UNDRIP to people. What does that mean? And it was a UN Declaration of Rights for Indigenous People, but help us understand what that means and why BC adopted it.
The UN Declaration, it's not an international treaty. It's a declaration of the United Nations General Assembly. It has no force effect in international law. And it really actually doesn't have a force effect in British Columbia as law yet. But it arose from a long series of negotiations internationally with Aboriginal people around the world, who got together and defined their view of their human rights, their fundamental human rights, and put it in a document which the UN then basically gave its blessing to in the form of a declaration. So it's not binding. A lot of people have said it's aspirational. It's certainly a useful document because it sets out Indigenous views of their.
I think we're losing you on your internet connection there.
Oh no.
I think you're back now, though.
Okay.
It tends to be chunking out a bit there, though.
Okay. So that's UNDRIP. The BC government's adoption of UNDRIP came from the report of the Truth and Reconciliation Commission and its 97 calls to action. And the relevant ones are, for folks who are going to look it up, numbers 43 to 47 talk about reconciliation. And one of those was a recommendation that Canada adopts the UN Declaration, UNDRIP as we'll call it, as the necessary and only appropriate framework for reconciliation in Canada. Now, Canada also already has constitutional affirmation of Aboriginal rights. So UNDRIP is something that is put on top of that.
Do you think we should just lose the video and maybe the audio will stick? Because we're losing you. We're kind of like jumping in and out. Maybe just drop your video feed.
It's probably the video. Hang on a minute.
Maybe you can just put a picture of him up there and see if that helps. Yeah, just keep going though, and we'll tell you when you can cut your video feed and see if that helps at all.
Okay. Sure. All right, so that recommendation that the Truth and Reconciliation Commission made was arguably outside of their residential school mandate. So I'm not sure that they had to make that recommendation, but they did. In 2019, the Horgan government in BC chose to legislate to incorporate UNDRIP into all of BC's laws. And so, hang on a sec. And so they passed the BC Declaration on the Rights of Indigenous Peoples Act in 2019. That's become known now as DRIPA. So when people...
I think we're still... Did you cut the video feed and still losing the audio?
Hang on.
Okay.
Hang on a second. Let me see if I can do that.
We're just trying to fix a connection here, so if you just be patient with us, we'll see what
Sure.
we can do with the connection here.
Yeah.
You want to try that, or?
I can try that.
Okay.
Okay, so BC basically passed DRIPA. And DRIPA, people will hear about DRIPA all the time in the news, and they just need to understand that the point of the BC legislation was to provide a process under which all of BC's laws, and I mean all of BC's laws, would be brought into alignment with the 46 articles of the UN Declaration, so of UNDRIP. So people will hear DRIPA, UNDRIP. It basically, in BC now means more or less the same thing. Following the BC legislation, the federal government did its own version, and it basically copied BC's legislation almost word for word. The federal version is called UNDRIPA, which is the UN Declaration on the Rights of Indigenous Peoples Act. So that's Canada. So what this all means is that BC basically in 2019 adopted UNDRIP as the framework for Indigenous reconciliation in British Columbia. And they did that, interestingly enough, despite the fact that Canada has quite substantive constitutional law on reconciliation under Section 35 of the Constitution Act. So arguably there was no need to do DRIPA. It was a political choice by the present government. What it does is it basically, in effect, piles a bunch of obligations on top of Canadian constitutional law, which is creating, I think, a certain level of legal confusion, certain level of public confusion, I'm sure. But that was the choice that was made in 2019.
And a certain level of uncertainty, especially when we're talking about land, and that relates back to that Richmond decision here that you and I talked about in the past there, which is led to that judgment for the Cowichan tribe. No problem. Led to that judgment for the Cowichan tribe. Now Pierre Poilievre has picked it up as well and says that this needs to go to the Supreme Court. You and I talked about that as well. And I think you talked about how the BC government here has decided not to argue extinguishment, which I think you said was the only real defense for lands that have already been awarded by the Crown to private hands.
It's not the only defense. It may, in fact, not be the very best defense, but it's one. The law is not, I know I've heard some scholars say, well, the law is, including counsel for Cowichan, saying the law is crystal clear on the fact that extinguishment is not an option for a defense. There are several points of view about that. I don't think the law is as settled as counsel for Cowichan has made it out to be. But there are other arguments as well. The Supreme Court of Canada talked about expropriation as early as 1990 in the Sparrow decision. So what does it mean for a right to be expropriated? The court basically said expropriation is a possibility, and if it happens, compensation has to be paid. So that's another argument to run in the Cowichan tribe's case, because the Supreme Court of Canada has already said it. It said expropriation can happen. So there's something that needs to be explored there in the context of that particular court case.
Why is the government intentionally kind of keeping this out of the loop, though? Like, why are they not making this more public? It seems like that's the big thing here, is that it's a lot of this stuff. The concerns or complaints that it's done a lot under the cover of darkness here.
I would say my assumption is, and I don't actually know the answer to the question, but my assumption is that there's a feeling inside of government that allowing the public to actually have a say in any of this stuff is going to result in the agenda not proceeding the way the government wants it to. And so I think a decision has been made internally that secrecy is the way to do this.
We're really struggling with this connection. So I think we lost you there for a second. Again, you skipped out again.
Okay. Okay.
So there's some developers that I've talked to that say this is a huge concern and it's made BC uninvestable. Do you agree with those concerns? Do you think it's like that this Richmond decision and Haida Gwaii has led to a place where developers are really concerned about moving forward with their developments here in British Columbia?
Well, remember, there's two things. The Cowichan decision is actually a decision under Canadian law. And, the courts will do what they're going to do in respect of Section 35. The DRIPA stuff is all political, and it's been created as a BC piece of legislation. It's all political. So those two have to be distinguished, right? One's a court process under Canadian constitutional law. The other one is a big policy process. And I would say that Cowichan has created a lot of uncertainty. I think the sort of idea that Cowichan has application beyond Richmond for all private properties has had a big chilling effect. The judge actually didn't need to say that, I don't believe, but she did. And DRIPA, I think, is also having a chilling effect in that nobody knows what the rules are now.
Yeah, and capital will kind of go where it's treated best, and certainty is a big thing that capital looks for when you're trying to invest, and it's tough to invest when certainty is elusive.
Well, I know for a fact that the business community is having a lot of issues with the way this has been rolling out, and I would expect that they may start to be more vocal about that in the next while. So we'll wait and see. I would say that the biggest problem with DRIPA and UNDRIP is that there's articles in there, particularly in relation to land, that are inconsistent with Canadian constitutional law. And that's creating huge uncertainty. And so, for an example, we now have legislative policy being jointly drafted by the First Nations Leadership Council and the government because of DRIPA. And you said 2%, representatives of 2% of the population are co-drafting legislation for the other 98%. What's the basis for that? The Supreme Court of Canada in 2018, there is no obligation to co-draft or even to consult on the creation for any government. So that's a big question mark. And then these agreements that are being rolled out, the tendency is you negotiate them in secret. Haida is a good example. And then you present them as a fait accompli to the public. And of course, I guess it's based on the principle it's always easier to apologize than to let people know what you're doing. So apologize afterwards. But there's definitely a fait accompli aspect to this, which is we'll do the deals in secret, and then we'll tell the public. And in the case of Haida, the two governments chose not even to tell the public after they'd been into court to seek that consent order for Haida. Zero, nothing, crickets. The Haida announced it, the governments didn't. So that's an example, I think, of the kind of thing that's.
We're really struggling with this connection here. You're back again. You just keep cutting in and out.
sorry, it goes on in what they're calling reconciliation. The government is now negotiating Aboriginal title, like they've done on Haida Gwaii. To me, that's an incredibly scary proposition when you see what's happened on Haida Gwaii. But they're doing it, right? And they're also doing joint land use planning. Northwest BC, 20% of the provincial land base is now going to be jointly planned by Indigenous communities and the government. There's lots of examples of that going on. And then, of course, there's the legislation as well, right? We had the Land Act, joint and consent-based decision-making on all public lands. Now we have the Heritage Conservation Act, which is basically, in my view, the Land Act on steroids. So here we go again.
I guess the big question, though, is for people that bought land from the Crown, and whether it changed hands several times or not, in the private lands is where, like I hear from the public, it's the biggest concern. If they bought land from the Crown, and then the Crown or the judge awards that land to another title holder, and I guess the only recourse then is to sue the government to get your money back, or like what a landowner, like, I mean, the part you talked about in the last interview, like those Richmond properties basically have a cloud hanging over them, although the BC NDP has said they're going to appeal that decision. Well, we're having a...
I would suggest that the cloud is pretty significant in terms of uncertainty about the nature of those interests and their validity. So I get what you're saying. I think that unlikely to stand the test of time. So
I think what we should try to do, Jeff, because it's tough here. Can you try and log off and then log back in and see, because we're only getting parts
Sure.
of your answers. Let's just try to kick yourself out and then come back in. Let's see if that does any better here. You see if you can answer that last question that I posed to you on the Richmond properties.
Okay, so yes, people are right to be concerned about the Cowichan decision. There is it over those private interests. I think that the one thing that folks need to understand is that under Canadian law, it's not likely that the whole province of British Columbia is blanketed by Aboriginal title. Under Canadian law, we've had a couple of decisions that say it's probably about 6% of claimed territories. So this isn't everywhere, or at least it's unlikely to be everywhere, as far as the Supreme Court of Canada is concerned. So that's important to know. But this judgment, I think, will probably not survive on appeal. I would be very surprised if when it gets to the Court of Appeal or even the Supreme Court of Canada, that those courts are basically going to say, hang on a second, you can't, this is not, we're all here to stay. This is ridiculous. We have to find some legal theory, which the Supreme Court is very good at doing, to make these interests coexist in a reasonable way, right? So I think there's a good chance that this judgment won't be affirmed on appeal, but it's a crapshoot, and it's going to take 7 years to find out.
Yeah, so those properties are unsaleable at this point, I would say. I mean, and who would buy them unless it's, at a fire sale price and somebody wants to take a gamble on it, because they do have that significant cloud hanging over them right now.
Yeah, they do. The implication of the judgment, at least, is that they are subject to Aboriginal title, and it's not clear what that actually means. There's no declaration that that's the case, but it's a clear implication from the judgment that the cloud is now over those private interests, for sure.
And then there's Pierre Poilievre's making noise, the Conservative part of the opposition, but not a lot of statement from the Liberals at this point. As to, and where do you see the NDP and the Liberal government going with this? I mean, they're the ones in power on both sides, federally and provincially. They're the ones that have, the reins, and they one seems to be silent, and then the other one seems to be secretive.
Well, the reality is that the BC government, any provincial government, can bring a court of appeal or another court of appeal. Federal government is the only government that can bring a reference case to the Supreme Court of Canada. The problem with the reference case is that the Supreme Court of Canada is going to want to have a factual basis for making a determination. They're not going to want to hear a case like this in a vacuum. And that's the problem with the reference. There's every chance, I think, that if a reference was applied for, the Supreme Court of Canada would simply say no. They'd say, let it go through the appeal process. We want to hear from the Court of Appeal. We want to hear all the issues, and we want it argued fully in front of us. And I don't think a reference on this, which is
I think it's just too early then. Just too early for that.
I don't think they would accept it.
Okay. And then you said there's about 6% of properties. How does someone find out if their property is part of this 6%? Is that common knowledge out there, or how does what are those?
No, and the whole issue of how is Aboriginal title going to be determined case by case in BC and geographic area by geographic area is another crapshoot. So all I'm saying is that we've had a couple of cases in BC which have resulted in only a relatively small percent of the claimed territory being found to be actually owned Aboriginal title lands. So if that were to continue, then it would mean sort of a 6% solution. But every First Nation in BC is different in terms of their historic occupation of land, right? So you can't predict it, and no, there's nowhere you can go to say, is my land on a piece in an area where there's a likely strong Aboriginal title claim.
And I understood from another politician I spoke to that BC is kind of more subject to this. Like there's been some treaties signed in other provinces that don't put them at such a risk that BC is at right now.
Oh, absolutely. A lot of the rest of Canada was settled under treaties, and the famous numbered treaties, I guess, that go all the way from Ontario all the way through to northwestern or northeastern corner of BC. So treaties, 3, 4, 5, 6, 7, 8. Those provide quite a level of certainty in those provinces compared to us. And we only had 14 small treaties done on Vancouver Island when it was a colony. And Treaty 8 covers part of the northeast corner of British Columbia for historical reasons I won't go into. But that's it. And the rest was not, there were no treaties in the rest of British Columbia historically. And that's a large reason why we're where we are at today.
So British Columbia is I guess the most at risk province that you would see?
Some of the eastern provinces, New Brunswick, the treaties that were done in the Maritimes were peace and friendship treaties. The Supreme Court of Canada has already said that. So they're not extinguishment treaties like the numbered treaties. So New Brunswick is right now under an Aboriginal title claim for, I think it's a giant percentage of the entire province.
Wow. So what is the recourse then like for people? I mean, I guess they can reach out to the politicians and see what they can get done, but so is the recourse then sue the government? Like say you owned a piece of property like in Richmond there, you own that property, you bought it from the Crown, or whoever you bought it from that bought it from the Crown, because all the property is awarded by the Crown. So do you sue the government, and how long does that take? Because isn't that basically expropriation of the property as well, or is that what you were talking about in the beginning? Or
well, yeah, it's the issue is that if the Aboriginal title is a senior interest in land to the private title, and if it's true that nothing the province ever did in granting those fee simple titles had the effect of displacing, expropriating, extinguishing the Aboriginal title that's over the same lands, then yeah, the constitutional Aboriginal title is going to preempt the private titles. And yes, you're right. You would have to, in that circumstance, you would have to try to sue the Crown for giving you a bad title. Of course, before that happens, there will be all kinds of issues about the validity of the Land Title Act. The government will find itself in a very difficult position because it's guaranteed everybody's private titles in British Columbia under the Land Title Act, right? So big mess.
It could find itself bankrupt in a hurry. Because where would it get the money?
Yes. Yeah.
Which makes it even more troubling. And I think that's why, I guess Pierre Poilievre has now taken up the issue. And how long before this case goes to appeal court? Like, what are we looking at for a time frame? Like, is there a court date set?
I don't know when the BC Court of Appeal is going to hear this. I'm thinking about a 7-year time frame for this to get all the way through the Supreme Court of Canada and a judgment issued. So we're talking a long period of time, long period of uncertainty.
Yeah, so for the developers, like I said, I've talked to some developers and they say, well, like right now we would just go to Alberta or the US or whatever instead of trying to develop large tracts of land. It just seems like it's a, because then, everybody gets sued in the lineup, right? Especially when somebody's aware that there might be some land claims on certain properties as well.
Well, the other thing I wanted to say about UNDRIP is that Article 26 of UNDRIP says that Indigenous people own all the lands and resources within their claimed territory. There's no definition of territory. It's whatever you say it is. Mm-hmm. And it's 100% ownership of land and resources. So that seems to have been the model that was applied on Haida Gwaii.
Yeah, because that means
and if that's the template, as the Premier has said.
Because then, when we were talking about forget about property developers, let's talk about logging companies, mining companies, all that kind of stuff. Obviously, they'd have to make deals with, they don't even know who owns the land at this point. What is the deal with the government or the deal with? I don't know.
Right. So the Supreme Court of Canada has tried to be clear on that and said the province can continue to manage its lands and resources until Aboriginal title is out.
We lost you again. Can you repeat that? I think we lost you there. I think that was an important question.
I'm sorry. The Supreme Court of Canada has basically said, that first of all, it's pretty clear that they're talking about a much smaller areas of Aboriginal title than what UNDRIP seems to be talking about. And I think that the court's been pretty clear about they want this form of constitutional reconciliation to be balanced. And one thing I've noticed about the rights in UNDRIP is they're not balanced at all. They're absolute rights. They're set out as absolute rights. So there's no balancing like there is in the Supreme Court's jurisprudence.
So you've been practicing law in this area for 30 plus years. You're probably one of the more experienced people in this area. And you say it's going to be 7 years to find some resolution to this one way or the other, a certainty. What do we do in the meantime, I guess, is the question.
Well, as I said, the Cowichan situation is actually a court-imposed situation. So the best we can do is appeal vociferously, I guess you'd say, to the BC Court of Appeal and see where that goes. I will say most Indigenous communities in BC have been very careful and very reluctant to go after people's private property. So even in Cowichan, the Cowichan tribes did not ask to displace private property. But unfortunately, they asked for Aboriginal title to be over a certain area of land, and that just happened to contain a bunch of private parcels. So they're not going after people, not at this stage.
But even in that judgment, there was other First Nations that were also laying claim to that same land, though. It's making it kind of a bigger mess too.
Well, British Columbia is actually blanketed by overlapping territorial claims. Probably the biggest percentage of the province is blanketed by overlapping claims. So the situation in Cowichan is not unique. For Musqueam and Tsawwassen to say, hang on a second, we don't agree with your principle that this was your land, Cowichan. We say it's our land, historically. And of course, that overlapping claim situation has never been resolved properly in BC. There's been several attempts made to get First Nations to resolve it. Governments don't want to step in to try to resolve it, but it's just another complicating factor in our province's circumstances.
So what's the best alternative for people to present to the like how do we go forward? I guess is the question. Like what should the public do? What should opposing government do? I don't like it's unclear. Like you're saying, we have to wait 7 years for this decision. And is there other cases right now before the courts that you're aware of that are looking for a similar decision to the Richmond decision?
I'm not sure of how many Aboriginal title cases there are in front of the courts right now. I don't think it's a very big number. What worries me more is having watched what happened on Haida Gwaii. The present government is saying it's going to negotiate Aboriginal title for the Seychelles. And my question is, after Haida Gwaii, well, what's that going to look like? Are we talking the whole Sunshine Coast?
Yeah, so we're going to have you back. We're going to talk Haida Gwaii. We're going to have you back, and we're just going to do a whole show just on Haida Gwaii, if that's okay with you.
It is, yeah.
So I think that one's a big enough issue there that we can spend some time on the Haida Gwaii decision. And obviously, it would be better if this played out into the public forum as opposed to, like right now, it's being kind of like you said, being done, and then it's being presented, and then people's, just asking for forgiveness, I guess. But it's a tough thing to do when playing with people's lives and then their investments too, right?
I'm not a big fan of the secrecy agenda. I'm not a big fan of UNDRIP. I think Canadian law is quite sufficient to base reconciliation on. I think UNDRIP just adds a whole pile of uncertainty to a whole bunch of things. And I gotta say, as somebody who's studied UNDRIP for a long time, I find it completely vague. To me, it's Jello. And this idea that you're going to make all BC laws align with Jello, that doesn't work for me. I mean, it's too open to all kinds of different interpretations. And actually, I'd say as a last note, Jody Wilson-Raybould, when she was Attorney General of Canada, she made the comment that no, Canada was not going to make UNDRIP the law of Canada because it's too vague and it's unworkable. And so in my view, what we're seeing now in this province is the unworkable.
Yeah, we keep losing you here. So, can you just repeat that last one there?
Yeah, the last comment I made is that Jody Wilson-Raybould, when she was the Attorney General of Canada, stated that Canada would not make UNDRIP the law of Canada because it's too vague and it would be unworkable. And that's my point. It's in my view, it's unworkable in British Columbia as well.
Well, we're gonna leave it here for today, and then we'll book you in for next week, and we'll do Haida Gwaii, and then we'll hope for a better connection because it's definitely a struggle when we're getting half your answers.
Sure, I understand.
And I do thank you for your time because I think it's such an important issue. A lot of people are definitely starting to sound the alarm, and right now, the BC economy needs some certainty in investment and stuff like that. And like I said, I'm hearing from people that it's getting tougher and tougher to make investment decisions when there's other magnets that are pulling investment, especially large dollar investment, to other areas. And
my view is if you're doing reconciliation in secret, how does anybody know what the rules are now?
Right. I mean, just if it's out in the open and this is what it is, then you can make decisions, right? And so then you can weigh that,
Yeah.
and like some of those decisions might be great then, right? Because I've purchased land on or property on from First Nations, but I know fully well going in that that's what it is, right? So, that one's safe, right? Because you bought that and you're getting a 100-year lease or 130-year lease. That's the deal.
Right.
You've been there full well knowing that's the thing. But if you bought land from the government, the Crown, and all of a sudden there's a different title holder, it could completely devalue your property. I don't think anybody knows what the answer is to that.
Well, there's a principle in law called, a bona fide third party purchaser for value. And I think that actually is probably one of the big arguments that's going to be made in the on the appeal, is that these people bought their properties in good faith.
Yeah.
And they knew nothing about this Aboriginal title burden on their properties when they bought them. So they shouldn't be penalized.
Yeah. So I think that's the question, and I think the BC government, if it could do more of this stuff out in the open, I think just telling people what the possible ramifications are. I know somebody's saying, don't fearmonger, but I mean, this is already out there. Developers are making decisions based on this, and this.
I don't think it's not fearmongering to ask for transparency.
Yeah, I agree. I think we'll leave it there because, again, the connection's tough. But again, Jeff, thank you. You have so much experience in this area, and we look forward to having that full discussion on Haida Gwaii. And if you have questions, and this guy, one that keeps writing in here, if you have questions that when we have Jeff back on for Haida Gwaii, I mean, great, you seem to have some knowledge here. So then send your questions, and we'd love to have them in there as well, because we leave our comments open as we do our things, as opposed to like some of the other outlets where they don't let you comment. So there you go. Thank you, Jeff.
Thank you.
And thank you for watching Now Media.
We don't just report the news. We live here too. We're your neighbors, bringing you stories that matter to all of us. No government funding, no outside influence. Kelowna Now, local, independent. News